Today, we will talk about what living wills are and how to make one. A living will, also known as an advance directive, is a legal document that specifies the type of medical care that an individual does or does not want in the event they are unable to communicate their wishes. For example, in the case of someone who is unconscious due to a terminal illness or life-threatening injury, doctors and hospitals consult the living will to determine whether the patient wants life-sustaining treatment, such as assisted breathing or tube feeding. Living wills and advance directives are only used when facing a life-threatening condition and unable to communicate desires for treatment. Doctors don't consult the wills for standard medical care that doesn't involve life-threatening situations. Every state provides for the drafting of a living will, although some states call the document a medical directive or a healthcare proxy. A living will covers many life-threatening treatments and procedures, such as resuscitation, ventilation, and dialysis. It also allows one to indicate whether they wish to donate organs and tissues after death. Even if the patient refuses life-sustaining care, they can express the desire to receive pain medication throughout their final hours. One can extend the living will to cover situations where there is no brain activity or where doctors expect them to remain unconscious for the rest of their life. Before making a living will, it's best to understand that it will not serve as a last will and testament, whereby property and personal effects are allocated to others upon death. The living will details the goals and wishes of a person in the event they can no longer care or make decisions for themselves. It might be helpful to segment the living will into categories of care, such as whether to receive life-sustaining care, or when to receive pain management. In addition to the living will, one can select a healthcare proxy who is allowed to make decisions if they are incapable of making those choices. Some states call this individual a healthcare power of attorney. Living wills cover many medical decisions, but a healthcare proxy can consult with the doctor on other issues that may arise. A living will and a living trust are different. A living will involves how the subject person will be cared for if in a compromised or incapacitated state, while a living trust deals with the property and assets of an incapacitated person. They both are executed when the initiator lacks the capacity to make decisions for themselves. You will not lose control of your living will while you have the ability or capacity to make decisions. If incapacitated, the proxy has the legal authority to act on your behalf, making decisions about your healthcare. A living will addresses the type of medical treatment given to a person who is unable to make those decisions for themselves, while the last will and testament carries out the expressed wishes regarding the distribution of a person's property and assets after death. A bank's living will is a legal report filed annually by companies instructing how the business will be liquidated in the event of insolvency. Here are 1 key takeaways. 1. A living will is a legal document detailing the type and level of medical care one wants to receive if they are unable to make decisions or communicate their wishes when care is needed. A living will addresses many life-threatening treatments and procedures, such as resuscitation, ventilation, and dialysis. A person can appoint a healthcare proxy to make decisions regarding care when they are unable to do so. A living trust is a legal document that addresses how the assets of the incapacitated person should be managed. People can enlist the services of an estate planner or an attorney to help draft or review a living will. Hope this would help. Thanks for watching.